On the issue of national security letters, the Inspector General did show conclusively that these powers were misused and abused by the FBI.
And I think anytime you have a situation without oversight, it leads to, at a minimum, errors, if not outright abuses.
We want our federal law enforcement to be focused on genuine threats to our security and not squandered prying into the lives of innocent Americans. Well, under the law that was in effect before the Patriot Act, the government had to be requesting records about a suspected terrorist, or records that, quote, pertained to a suspected terrorist. What the Patriot Act did was completely unloose that restriction and allow the FBI to obtain financial records, internet transactional records, communication transaction records, without showing that there's a connection between the records sought and a suspected terrorist. The new standard passed by Congress in 2001 was to allow the FBI to obtain an enormous array of records, sensitive personal records on Americans, based on the claim of the FBI to itself that the records are relevant to an authorized investigation without any judicial check.
Certainly the expansion to that extent enabled the FBI to monitor political activities far more than was previously the case, and it was precisely the political spying that was taken under the guise of spying for national security that led to many of the restrictions on the FBI through executive orders issued by the Attorney General, and I was involved in some of those, Attorney General Edward Levy's guidelines revised under Attorney General William French Smith, and even federal statutes that generally forbade the FBI from gathering information solely based upon First Amendment activities.
If there were some evidence that they wanted about a suspected terrorist, someone who they had reason to believe was conspiring to commit an act of terror, I think they could easily get an order for whatever records were relevant to that investigation. What has happened here is that the FBI says that it needs these powers to basically build a case. They call them the building blocks of their investigations, meaning they don't have very much information. And in fact, if you look at the criminal law guidelines of the FBI, in order to open a full investigation on someone, there has to be a reasonable indication of violence. To open a preliminary investigation, by definition, they don't have a reasonable indication of violence. In the terrorism context, we don't know precisely what standard they're using, but when they open a preliminary inquiry on an American, by definition, that probably means they don't have a reasonable indication of violence, and yet they keep whatever information they obtain about people. You'll never know if your records have been turned over to the FBI as part of one of these fishing expeditions. The business that turns over your records is barred from telling you ever, or telling the press that they've turned over your records, even if you're innocent, even if it were a fishing expedition. And so I think it's a very serious matter for American privacy, and the Inspector General of the United States indicated that the FBI keeps the records even if a person is cleared or a case is closed. So suppose you had a neighbor who didn't like you, who called an anonymous tip on you, and the tip was completely baseless. If the FBI issued a national security letter for your credit report, your bank records, your phone records, your internet transactions, the FBI would retain that information about you even if they realized that the tip was bogus.
Ever since the Patriot Act came out, librarians had been very concerned about a number of clauses within the Patriot Act that apparently allow the federal government to investigate the activities of library patrons, and also come with a perpetual gag order, as does the National Security Letter itself. Plus, people have a trust in library. And the library is a place where you can go to find out information on anything that you're concerned about, whether it's a political issue, a medical issue, a legal issue, and feel there's some confidence that the information you're getting in a library is in the library because it's good information. You know, if you're a woman who wants to research spousal abuse or divorce, it's not something you want the entire community to know you're concerned about, or whether it's cancer of a man or a woman, or anything that, you know, people go to a library with things that are are highly confidential. They had called about a week before they delivered the letter. They had called Mr. Sutton, our telecommunications manager, said they were going to serve Library Connection with a national security letter, and asked whom it should be addressed to. And he said it goes to the executive director. And after the call, he ran in and said, "You're getting a national security letter." Of course, I'd never heard those three words put together like that before. I called our attorney. She hadn't heard either, but she had a graduate law student available and said, "I'll put him on the case." He came back with the information that a national security letter is essentially a subpoena-like instrument that the FBI can issue without any judicial review, and that an ISP in New York, an internet service provider, had challenged compliance with the national security letter, and the district court had ruled that on its face the statute violates the First, Fourth, and the Fifth Amendments, so clearly an unconstitutional piece of law. Armed with that, I'd made up my mind that if possible I would not comply. And when I called my attorney to say we actually received this letter and I wanted to contest compliance, she said, "Well, the problem there is the only way to contest compliance is to sue the Attorney General of the United States." And although I had the legal authority to do that in the bylaws of our organization, I really felt morally I could not commit our organization to such a contest on my own. And I asked the three members of our executive committee, Peter Chase, Barbara Bailey, and Janet Nocheck, who are library directors themselves, to act on behalf of, and they're authorized to act on behalf of the board. I said, "We really need to talk about something, and you need to make a decision." So they came in, heard the evidence, and decided that yes, they would contest in court compliance with this. This is the national security letter presented to Library Connection. It was delivered by two FBI agents. They pointed out to me the paragraph that essentially constitutes the gag order. I had learned from my attorney that these requests had been judged unconstitutional by a district court in New York. So I said to the FBI that I had reason to believe the request was unconstitutional, and would they mind if I discussed it with my lawyer. And they said no. They wrote a number on the back of their business card and left it with me and said, "Have your lawyer contact this person." They wanted any and all subscriber information, billing information, and access logs of any person or entity related to the following: IP address 216.47.180.118, date February 15th, 2005, time 1600 to 1645 Eastern Standard Time. This address goes to a router at a library. 5 months, and routers use address translation. Every time you turn on a computer at that library, it's randomly assigned a different address. So there's no path between that router and a specific computer at the library. And 5 months after the fact, there's no idea who was even in the library that day. We interpreted this to mean that if we were going to comply, we would have had to tell the FBI, this is the library, here's the entire patron database. And if you really want all the records associated with this entire patron database, that's all the books they were reading, all the activity they had. Far too sweeping. And there was no reason for us to believe that whomever was using this computer at that time was even a registered patron at that library. So it was really fishing expedition. The whole problem with a gag order on everyone is that it allows no oversight, not only in the issuance of a national security letter, but it allows no oversight over what the FBI is doing. And I think any time you have a situation without oversight, it leads to, at a minimum, errors, if not outright abuses. I think that's a very useful addition. And I'm glad. And the Inspector General sampled just a very small sample, but found a preponderance of violations of the FBI's own internal use rules. I just don't think you can do anything in secret. and assume it would always be done right.
We know now, after the audit of just 3 years of FBI practice, that they have made over 150,000 requests. I think the true number, if you look at the past 6 years, is probably at least twice that.
How can they issue several 100,000 national security letters and no one has ever heard about it? It's because every recipient has to carry the secret of being a recipient to their graves. We did ask for immediate injunctive relief from the gag order because Congress was in the process of considering the renewal of the Patriot Act. And we very much wanted not only to let our own board know what we were up to, but to go to Congress and tell them that despite what both Attorney Generals had said and were saying, that indeed the Patriot Act was being used against libraries, and we wanted that corrected when the Patriot Act was renewed. The gag order was lifted, but the lifting was stayed to allow the government to appeal. They did appeal, and we went to appellate court in New York. But about 6 weeks after the Patriot Act was renewed, the FBI, the Justice Department, informed our attorneys that they would no longer oppose the lifting of the gag order in court. But by then it was too late to go to Congress. That's why the four of us are the only people in the United States who can talk about having received a national security letter. The government said that they had obtained the information they were looking for by other means. I assumed that I did what any citizen of the United States would do, and who knew that they were being handed an unconstitutional request and say, no, I don't think I'm going to comply with this. But perhaps the average person doesn't know that it's unconstitutional. After all, had the FBI come to me, flashed their badges, said, this is a matter of grave national security, will you cooperate with us? The impulse is to say, of course, I will. I had the luxury of knowing that the instrument they were using was unconstitutional, and in reading the letter, I could tell that since they were concerned about something that happened 5 months in the past, since they wrote the letter 2 months before they bothered around delivering it to me, they were not in hot pursuit, and it was not, by refusing to cooperate, I didn't feel that I was jeopardizing the security of any of my fellow citizens. And had I been wrong at any time, they could have gone to a judge and said, you know, we have probable cause here, will you sign a decree? And we've been happy to cooperate, but they never elected to go before a judge.